So you walk into your apartment and you fall on some faulty stairs.
Do I have a case? In this video, we're going to answer that question and several others where we will go through your rights as a tenant, how to build a strong case, pitfalls to avoid, and knowing your options.
So when we're dealing with faulty stairwells or faulty staircases, we always look at 5131 in Georgia, which is basically the premises liability statute. So if you are a tenant, the landlord owes you a duty to keep the premises safe. Landlords have to be reasonable in making sure that things like the stairwells are safe, the hallways are safe, there's no cracks in the concrete and things like that. So that's typically the code section we look at with any premises liability case in Georgia.
Yeah, and that's really where when we talk about your rights as a tenant, specifically to a fall in a stairwell or on a staircase, it's usually going to be because of what we call a static defect. In other words, there is some defect in the stair itself, there's some defect in the area that you would walk through. And typically in most situations, those are pretty tough cases because if the apartment owner or the business owner can show that you had equal knowledge of that defect, in other words, you had walked past it before, or you had stepped on the stair and it had wiggled or something like that, then that would defeat your recovery, because the whole idea behind bringing what we call a premises liability case is to show that the owner or the occupier of the premises had superior knowledge of the hazard over you as their guest who was hurt. But in situations where you're dealing with defective stairs or stairwells, there is a very narrow exception under Georgia law that's called the necessity rule. And basically what the necessity rule says is that if the path that you have to take to get into your apartment, if you have to go through those stairs or go through that stairwell, if that is the only way to get in and out of your apartment, then the equal knowledge rule does not defeat your recovery, your ability to seek a recovery against the property owner.
Right, and that's right. And I think kind of going back when you talk about static, generally people think of like trip and fall, slip and fall, or anytime they fall down. In any case, you have the two types of categories: static, which are things like a curb, right? That's a static defect, a cracked sidewalk. The foreign substance are things like water spilling on the floor, grease spilling on the floor, things like that. So there's different things you look at with each sort of hazard. But right, to your point, talking about stairwells and things like that in an apartment complex, if that is your only way to get in and out, the whole equal knowledge thing, it's easier for you to get past summary judgment, knowing that that's the only way that you can get into your apartment.
Yeah, and we'll just give a real quick specific example of static versus foreign substance as far as going in and out of an apartment goes, so you understand the difference. The static would be if you're walking up the stairs and there is a broken step on the stairs, right, or one that's not tight or it's wiggly or whatever, and then you step on it and it breaks. That's a static defect. A foreign substance defect may be where, say, a apartment maintenance worker is walking through your stairwell and spills a bunch of cleaning solution on the floor. You had no idea it was there. You go walking through there and then boom, you fall in it and you get hurt. That's a foreign substance.
So if you've been injured in a slip and fall or trip and fall at a stairwell in your apartment complex, you want to build a strong case. And one way to definitely do that is take pictures, right? You got to take pictures and be able to show what the hazard was or what caused you to fall.
Yep. Another thing that's going to be essential to proving your case is your lease document showing that you were a tenant at the apartment complex, and if you weren't a tenant, that you had permission to be there. Because a tenant's considered an invitee, which means that the apartments owe a duty of care to that tenant to keep the place safe. But it also extends to the tenant's guests. So if I'm living in an apartment complex and I invite Chase to come over to watch the Super Bowl or watch a ball game or something like that, and he comes up and is hurt, then the duty that the complex owes to me also extends to him. So any paperwork to show that you, as the injured party, was legally there and considered a paying guest or an invitee, go ahead and secure that evidence as well.
Yeah, and also evidence that the apartment complex knew or should have known of that hazard. Because with any premises case, like we talked about earlier, it all boils down to knowledge, right? So if you have any other neighbors and things like that who might have complained to the apartment about those stairs, or if you yourself complained about the stairs known as a potential issue, going back to the necessity rule, all those types of things are very important to build a strong case.
Yep. So basically to prove that the apartment complex had knowledge of it.
Right.
But also, if you're hurt when you fall, then you need to get into a medical professional, either a doctor, immediate care or urgent care clinic, chiropractor, whatever, ER, depending on how bad your injuries are, to have those injuries documented by a medical professional so that they can later say that this fall caused whatever injuries it is that you may have.
Right. Always get checked out if you're in pain, for sure.
Yeah. And when you do that, you need to keep a list of all the medical providers that you have, as well as any bills and things that you may receive for that medical care, because that is obviously a part of the damages that you have. And then if you miss work and things like that, obviously keep up with documentation to show how much money you lost for not being able to go to work.
That's right. All right, so next let's talk about pitfalls to avoid, right? So basically, if you do everything we told you to do just a moment ago, then you will most likely avoid all the pitfalls. But Joel, what's one of the big pitfalls you want to avoid?
Not hiring a lawyer.
That's right.
For a premises case, it's much different than, say, a minor car wreck case where somebody bumps into you and you're hurt for a few days and you can settle the case fairly easily with the insurance company. With a premises case, no matter what state you're in, first off, they're all going to be very state specific. So the laws are likely to vary from state to state. So we're in Georgia and we're talking about Georgia law, but if you're in Alabama or North Carolina or Ohio or Wyoming, the laws are likely different in your state. So you want to hire a lawyer in your state that can practice law there, that's familiar with what they have to prove specifically for your state. These are just not the type of case that you want to go it alone with, because if you miss one little step along the way, then it could destroy your entire case.
That's right. They're very fact specific, like you said, and a lot of times these cases have to be litigated, and then once you litigate them, you usually get to that stage, which is called the motion for summary judgment stage, where the defense or the defendant or the landlord, whoever it is trying to throw the case out altogether. So you got to make sure you build the case properly, get all the facts and evidence and things like that you need in order to get past that summary judgment phase so you can get your case to trial.
Yep. I think the second pitfall is not securing the evidence that you need, because a lot of times by the time, if you fall on a static defect of stairs or the stairwell, by the time you call a lawyer, well, the apartments will have already fixed it.
That's right.
So then it's impossible for the lawyer to go out there and document it and do a reasonable inspection to gather all that evidence. So at a minimum, if you're unable to take pictures, have someone else take pictures for you. And if you can't do either of those, then it's probably best to reach out to a law firm as quickly as you can so that lawyer can do the investigation for you.
Right, and what the lawyer will do too right off the bat is send what we call a spoliation letter, right, which is basically a letter to the potential defendant that says, hey, you are on notice that this happened. If you have any evidence, things like videotape, any documentation, anything like that could in any way pertain to this fall, this incident, these stairs, you need to preserve it. Mm-hmm. So that way it puts them on notice and you can preserve all that evidence.
Yeah, and I think another pitfall to avoid is you can be kind of hot and there can be some emotions that are very strong after you fall, and especially if you believe that the apartments have known about this problem and didn't fix it. But the last thing you want to do is bust into the leasing office and start yelling and cussing and screaming at people and threatening people because they didn't fix it. You just want to handle it in a professional manner and document it, and then get it into the hands of a lawyer who knows what he or she is doing to pursue your case.
That's right. So lastly, I think it's just best to know your options, right? So it just goes back to what Joel said, it's always, I think, important just to call a lawyer and speak with them, get some advice, know what you can and can't do, because you can go up about it your own. You can try to work with the insurance company, the risk management department, whoever it might be, to get your case resolved. But it's almost always going to be pennies on the dollar, especially on premises cases, because they're so fact specific. And I don't want to say the cards are stacked against you, but it's a lot more of a burden to carry. And a lot more evidence gathering and things like that to have a successful case. You can hire a lawyer to try to settle the case for you without putting it in suit. You can put it in suit, try to get it settled during litigation, or you can go all the way to try the case all the way through the Court of Appeals. But it's always, I think, important at a minimum to speak with a lawyer and know your options if you've ever been injured in a stairwell or anything like that at an apartment complex.
Yep. All right. Well, we hope this video has been helpful to you. If so, give us a thumbs up, hit that subscribe button. Otherwise, we will see you next week, where we will talk about, do I have a case when I'm injured by an airbag?